I'm Tess Downing, founder of Complete View Financial, and welcome to this month's video blog. Today I want to highlight the importance of estate planning and why everyone over the age of 18 needs to have certain documents in place. I realize estate planning is a hard topic. Essentially, we're speaking of our eventual death or possible incapacitation. So regardless of your assets or income, estate planning is a vital piece of the whole financial plan. So today I want to highlight a few things that we need to think about when executing estate documents, why it's so important, and a few other considerations we need to keep in mind. So number one, why is estate planning important? Estate planning can help us ensure that all of our assets, including those that pass to beneficiaries, will be distributed according to our plans. It can help preserve assets for future generations. It can help provide support and financial stability for your spouse and your children, or even support a favorite charity or worthy cause that you're passionate about. It can help minimize estate inheritance and estate taxes, and it can even ensure that individuals can make decisions on your behalf should you no longer be able to make those decisions if you're incapacitated. Second, understand your overall family situation and your net worth. So what are your goals with your assets? Are you concerned about whether your heirs have the ability to manage and protect your overall wealth? Do you have any family members with special needs that might need additional hand-holding? Are you divorced with children from a previous marriage? Do you own your own business? Do you have minor beneficiaries? Third, understand the overall tax implications. Estate and gift tax exemptions in 2020 total $11.58 million per individual, which means taxes will not usually become an issue for a married couple with assets less than $23 million. So as you can see, estate taxes aren't a huge issue for the majority of Americans. However, something to take advantage of and to think about is the annual gift tax exclusion, which means you can gift up to $15,000 per year per individual without having to file a gift tax return. And fourth, here's a brief summary of the types of documents that you will want to consider when beginning to think about your estate plan. Documents needed for incapacity or when you no longer can make decisions on your own. The healthcare power of attorney, or oftentimes called the medical directive, as well as your financial power of attorney. So these powers of attorney allow individuals whom you trust to make financial and healthcare decisions on your behalf, which might include speaking to a doctor or your financial advisor about important things in your life. Now, documents needed at your death. These would include wills and/or trust. These documents determine how your assets will be transferred at your death. A will is the most common estate planning document and lets you direct how your assets should be administered, to whom, and under what circumstances. If you die without a will, that's called intestate, the laws of the state in which you reside will govern the distribution of your assets. So we want to avoid dying intestate, so make sure at bare minimum you have a will. Trust can also be a powerful tool to avoid probate, which means going through the court system, and managing assets for minor children, and possibly minimizing estate taxes. Trusts are simply a legal arrangement in which assets are held for a beneficiary and managed by a trustee. Trust can be designed to be as flexible as you want or as restrictive as you want, depending upon your unique family situation. And lastly, here are a few other things to consider when you begin to execute your estate documents. Number one, please work with an attorney that specializes in estate planning. Do not use an online service, but a great tool and resource for you is called the American College of Trust and Estate Counsel. They have a great list of specialized estate planning attorneys. Number two, estate plans need to be reviewed every few years and refreshed with an attorney at least every 10 years. This is just due to the fact that life changes as well as the laws. We want to make sure our documents reflect current laws and current family situations. Make sure your decision makers, such as your powers of attorney, your guardians, and your trustees, know where your original documents are kept. And those documents should be kept in a safe place, such as a fireproof home safe or a bank safe deposit box. And once your documents are executed, you're not done. We need to now make sure that your beneficiaries are updated according to your documents, as well as possibly retitling certain accounts. And don't forget about the digital assets. These can include online profiles, as well as the fact that you might have accounts that others don't even know about. And so you want to make sure that there's a comprehensive list with username and passwords kept securely so that your loved ones or decision makers can access these accounts should they need to. And I'll end on this note. Don't forget to speak to your family about your wishes. Proper family communication, I think, is really, really important. We want to make sure that future generations understand your wishes and understand the family legacy that you hope to leave one day. Thank you for joining me for this month's blog post. See you next month.